Thank you everyone for joining us for another Learning Lunch hosted by FormatApproved.com. My name is Brian Johnson. I'm the Senior Director of Online Education with Format Approved, and I'll be your moderator today. Today's Learning Lunch will cover the subject of what to do if you miss the September HIPAA Omnibus deadline. We're joined today by Jim Johnson of Anaseed and LiveCompliance.com. Jim has extensive experience as a CIO and compliance specialist, which you can see described on your screen, and the portal he operates represents the future of compliance, in my humble opinion, as it provides a solution that enables security officers and providers to track and implement their compliance in real time. It's a very impressive tool, which we might have a chance to discuss a little bit later, but we certainly encourage our guests to learn more about it at the website listed on your screen, www.livecompliance.com. Learn more about it after the session, however. Now let's talk about HIPAA. But before we begin, some quick housekeeping notes. Please note that you can ask questions of our presenter at any time during today's session by entering them into the chat area. In the second half of our session, we'll address as many questions as time allows. If we do run out of time, answers to all of those submitted questions will be posted to our website and sent by email link later in the week. Also, please note that all registered attendees of today's session, whether you're with us now or registered for the event, all of those folks will receive an email with links to both the slides and the recorded versions of this event. So people often ask us if we'll be sending out the slides, and rest assured that we will. All right, Jim, well, first of all, thank you very much for joining us.
Oh, you're welcome. Glad to be here.
Well, there's a lot of questions out there around the Omnibus final rule and what people need to do, so let's get right into it. So, and maybe this place to start even before this question is, what is the deadline that they may have missed? And then we'll get into what should providers and business associates do if they miss that deadline.
Absolutely. So just to refresh a few of the dates, the Omnibus implementation of HIPAA was originally crafted January 25th of 2013 and officially went into effect on March 26th. The Office for Civil Rights and Health and Human Services gave business associates and covered entities 180 days to comply and to implement whatever changes needed to be made, which took us to the September 23rd deadline. September 23rd, 2013. And at this point, where we are is in a position where audits can begin. They were announced that they would begin around the November 1st, end of October deadline. And at this point, if anyone is not in compliance with the new rules, essentially what they're going to be is in what's called willful neglect. And I think later in the presentation we can touch a little more on that. But that's where most people are at this point.
All right. So in terms of what people should do now if they miss the deadline, maybe you can describe some basic lay of the land for folks out there.
Sure. So one of the first things that you're going to want to do, let's assume that you're a covered entity, meaning a physician's office. You're going to need first to designate somebody as a compliance officer. And the reason for that, that's a required measure. It's part of the new HIPAA Omnibus rules. It's required to have a compliance officer in your organization. And that person is to oversee and ensure that your practice is fully compliant and all of the measures are implemented. So that's really going to be your first starting point, is designate that compliance officer. If you're a business associate, maybe an IT company or a copier company or a transcriptionist out there, you too have to follow these rules to the same extent that the covered entities do. So you also will need to have a compliance officer. A few of the steps within the rules are going to be a little bit different, but for the most part, business associates, covered entities should immediately designate a compliance officer and understand what that role means. the role of a compliance officer really is, again, going to be that person who's in charge of implementation, that person who is in charge of knowing the policies and procedures of the organization, as well as the person who is going to keep up with what they now call this living document.
So that's a required step to be compliant, but it also can help people figure out what they actually need to do.
Absolutely. That's correct. That's why that's always a great starting point, because understanding even what the first steps are is really the hardest piece to this. And the reason why I say that is back in 1996 when HIPAA first came out, it was a 10-page document. At this point, just the Omnibus, not even counting the high-tech Act of 2009, is 563 pages. So you really need a good understanding of what is involved for you. And hopefully we're going to cover a lot of that today.
So why is HIPAA training so important?
Mm-hmm. Yep. So one of the requirements is also to have your workforce trained. And when we're talking about training, we are talking about privacy and security, but it's also very important to train on the policies and procedures of your organization. Your training, being the security and privacy, also needs to be saved for a minimum of 6 years. You need to be able to show that your workforce has been trained, has an understanding of what the privacy and security rules are, as well as what the policies and procedures of your organization are. So training is also required, and it's very imperative, because the first line of defense is always your workforce. Breaches, improper disclosure of protected health information, your workforce members are always going to be the best line of defense in ensuring that you're not involved in a breach.
So you've talked a little bit about some of the new regulations and the new how high-tech changed things. What are the differences between HIPAA as it was originally passed and HIPAA as it exists now?
Yeah, the best way to describe to everyone who is trying to understand, again, what to do now that we're past that September 23rd deadline, the biggest difference is, and the reason why business associates and subcontractors are so much involved now, is because back in the original crafting of HIPAA and all the way through 2009 when we moved into the High-Tech Act of 2009, what you'll see is the covered entities, the practices, the medical practices, the hospitals, the liability really fell on them. If they hired subcontractors or business associates, it was truly up to them to vet and ensure that the business associates were playing by the rules and were not disclosing protected health information. Well, the Omnibus really changes that, and now it puts the burden on every entity that has regular access to protected health information. So a good example could be a covered entity might have in place a business associate agreement with a transcription company. Well, the transcriptionist many times sign the business associate agreement and send it back, and that's all well and good. Well, under the Omnibus, that's no longer acceptable. That transcriptionist needs to be compliant under the same guidelines as that covered entity. So no longer does everything fall back on the covered entity. So it's very important that each organization read, understand, and begin the process, even though we're past the deadline, begin that process so you don't fall in willful neglect. Those are the most severe penalties that can and will be imposed.
Well, it's amazing talking to people out there. I really feel that there's a lot of folks who just don't understand how much HIPAA has changed since it was originally passed. It's really quite a
Hmm.
different animal than it once was.
Hmm.
So
Absolutely.
you talked about not, what you need to do to avoid being found in willful neglect. What's the difference between the old penalties and the new penalties? They're quite a bit stiffer, aren't they?
Absolutely. The biggest change that you'll see is a change in essentially one word, and it's listed down there on the bottom 2 bullet points. The old HIPAA terminology was covered entities may be fined. So if there was a breach, if there was gross misconduct or various things that just should not have happened, the Office for Civil Rights and Health and Human Services had the power to fine entities, and that was the terminology. They may be fined. Well, that terminology has greatly changed. Not only have the Omnibus Rule included business associates, subcontractors, but now the terminology of will be fined has been implemented. So no longer is it very subjective, where you might be fined based on what happened. Well, based on what happened, now you will be fined. So it's very important to understand that the Office for Civil Rights, Leon Rodriguez, who heads up the OCR, is taking this quite seriously, and as everyone should be concerned about protected health information, the Office for Civil Rights is also very concerned about protected health information.
And Rodriguez is a former prosecutor, if I recall, so he really brings that mindset to enforcement.
That's right. That's right.
And then the fines themselves, they're quite a bit higher than they used to be. It's up to $1.5 million for a breach now, if it meets the criteria. Is that correct?
Absolutely. Up to $1.5 million. And a thing to really keep in mind, as I consult all over the U.S., I hear a lot of organizations say, well, geez, if we got fined $1.5 million for repeat offenses within the same year, or let's say willful neglect, I would just close up shop and that'd be the end of my business. Well, that's not a good way to look at it, because the fines and penalties can be personally leveraged against the owner of a business. So don't think you could just not play by the rules because you don't really see the importance behind it. That is not a good approach. This is a very clear, easy to follow. It is very lengthy, but it is something that can be achieved. So it's definitely worth investing the time and energy in complying.
Yeah, that's a great point. Even if even if that was your answer, that I'll just close my business. What kind of answer is that when compliance is certainly something that you can achieve if you just put a little bit of effort in?
Yeah, and I think more and more, especially now that it's moving down the chain, so covered entities now have to rely on business associates and their subcontractors to be compliant. I think you're going to see not only patients looking for practices that are complying and protecting their information, but you're also going to see covered entities really taking seriously who they work with and if they are in fact compliant before they may award a job to a business associate. So it definitely will affect your business landscape to be compliant.
That's another great point. So you've touched on this here just now, but what does HIPAA mean then to business associates?
Yeah, so business associates really have not dove in to the years of HIPAA that covered entities have been attending seminars such as this and following the rules and really keeping up with what to do in their business environment. So for business associates, this is somewhat new, and understanding everything that's involved in this can seem quite overwhelming. And it's also surprising to a lot of business associates that they are actually a business associate. You'd be very surprised how many covered entities send out business associate agreements to be signed, and they immediately get signed and sent back. And that's very dangerous, especially with Omnibus, because business associates should not simply sign it and send it back. They don't realize what they are legally bound to. And business associates a lot of times don't realize how liable they are for the information that they work with. For example, on this slide we had put copier companies. Copier companies are very much a business associate because copiers now store data. They deal with faxing in and out. They deal with printing of data. And a lot of times copiers are tied directly into the network itself. So a copier isn't just something anymore that you put a patient encounter on and make a copy for the doctor. It is essentially a network that stores and has access to the enterprise. And that's something that you really need to be mindful of. It's not, well, we're not doctors, we don't see patients. That's really not what a business associate is. A business associate is an entity that has access to protected health information. So it's very important to take a look, if you're a covered entity, at all of your business associates. And it's very important, if you are a business associate, to take a look at how you interact with protected health information so that you could be sure that you are not only following the rules that have been laid out by the federal government, but that you are also protecting your business and ensuring that you know what you're agreeing to when you do sign those business associate agreements. One last point, Brian, on this topic. We now have, with the Omnibus, the satisfactory assurance. And what that means is covered entities, business associates, and their subcontractors need to have satisfactory assurance that who they are working with are in fact following the rules. So it's a very important process to make sure that you do understand where you are in that chain of protected health information.
Yeah, so I think that's worth emphasizing, that if someone signs a business associate agreement, what they're saying, they're basically attesting that they're going to have a compliance program and do what they're supposed to do. So if they just sign it and don't do any of the other things, that's obviously a big problem.
Absolutely, yes.
And on the copier company front, I was trying to remember the name of the company earlier this year, but there was just an astonishing fine around a data breach that involved photocopiers.
Absolutely, yeah. It's amazing. The amount of data that those devices can retain is remarkable. A lot of people don't realize exactly what copiers can do. So it's very important to take a look at all of the technology within your organization, and that really starts with a risk assessment.
Well, and just one more point to add to that is, I think sometimes we hear people claim that they're not business associates, or we hear a lot of assertions that, well, this company isn't a business associate, but it really isn't down to the company. The law determines whether you are or not. You can't just decide that you're not.
Correct. Yeah, excellent point. It depends on your organization's interaction with protected health information. And the next step to that is often a business associate might have a sales force. And let's pick on an IT company for a second. They might say, well, we have 5 IT techs, but we have 10 salespeople. Well, when it comes to training and taking the various classes that are required, maybe on your policies and procedures for your organization, as well as privacy and security, they feel, well, the techs need to have the training, not my sales force. And that's really not the case. The Omnibus states that your organization workforce needs to be properly trained. So it's very important not to just, craft your own distinction of who needs to be trained and who doesn't. You need to be knowledgeable on the laws and make sure that you're following those, because in the case of a breach, that's when you need to have all of the proper documentation. That's when you need to already have your workforce trained, and it's impossible to unring a bell, so to speak.
Well, we've already got a number of questions from our audience, and thank you for those. Keep those questions coming in. We'll save those for the end of our presentation, and then we'll go through them with our expert here. But let's continue for now. So I think this is a great question, because a lot of people want to do it themselves out there. What's the benefit of having a HIPAA compliance consultant assist an organization with ensuring that they're actually compliant? Why is that important?
A lot of times that's important because of just the magnitude of ensuring that you're putting not only your protected health information in the safest possible position, but you're also protecting your business from things that maybe you just don't know. So if you're the office manager and now you've been elected the compliance officer, well, that's not always a good situation, because if you don't have the time to dedicate to really understanding and implementing the proper policies and procedures, for example, making sure that your business associate agreements and all of these other things are properly handled, you could put that business in pretty severe jeopardy. Having a consultant who does this on a regular basis and knows exactly how to evaluate your organization, exactly what would be the best, most efficient implementation for your organization, can a lot of times help get you compliant quickly. Remember, we're past that deadline now. So for you to begin the process will take a considerable amount of time, especially if you don't have the knowledge base. You're already a full-time employee. There's a lot to do there. And what's going to happen at the time of an audit is they're not going to be very lenient when it comes to, well, we haven't had time to finish doing our workforce training or whatever the case might be, because remember, this went into effect on March 26th, and they did give a 180-day period to become compliant. So you already have been given that 180 days to get there. So a couple things. One is consultants do know a lot of things to just jump right in and help with. Additionally, the amount of time that it would take you to read and understand and implement everything could just be unachievable.
So what are some basic steps then? What are the basic steps that people really need to pursue to become compliant?
So I think the first three that are shown here on the slide are extremely important and must be the first steps in achieving compliance. They seem very simple, and they are, from the standpoint of knowing what's within each of them. And let me touch on that just a bit here. So a risk assessment. Risk assessments are required at least annually, and a risk assessment takes a look at various aspects of your organization. Let's just pick on technology for a moment. A lot of times if you have an in-house IT person, they have developed the enterprise, or they have implemented the technology, so they're not going to look at it necessarily from a standpoint of an outsider who can look at it with a different perspective. Risk assessments are extremely important to ensure that that you're protecting your information properly. Now, we say a minimum of a year. If there are any significant changes in your physical or organization, that might warrant another risk assessment. So this isn't something necessarily that every January 1st you should do. You should also take a look throughout the year at different changes within your organization that might warrant a risk assessment. Next will be your policies and procedures. Not only do you have to have policies and procedures, but the Office for Civil Rights says these can no longer be that 3-ring binder that sits on everyone's shelf. That we say we have HIPAA policies and procedures, and they're stored somewhere collecting dust. These policies and procedures have to be something that your workforce knows and understands, and it's something that can actually be acted on and protect your protected health information. Of course, lastly, here is your workforce training. I can't stress enough how important it is to have your workforce trained on security, privacy, as well as have them trained on your policies and procedures so that in the case that there is a breach or a security incident or what have you, they know what to do. Again, your workforce is probably the most important set of eyes and ears that can protect your organization from being involved in disclosure of protected health information.
And so just to follow up, that the purpose of that risk analysis is to really identify what the vulnerabilities are. So it's really kind of it's like the first requirement, if I recall, of the security rule. And the purpose of it is that then you can identify what you need to fix to actually be compliant. Is that a fair description?
Yeah, absolutely. And what you'll find with a good risk assessment is it will uncover gaps within your organization that need to be mitigated and that need to have, whether it's your IT company or whether it's somebody there in-house, depending on the size of your organization, that can remediate and implement changes, thereby bringing down your organization's risk and vulnerability.
And I love your point as well about the policies and procedures, that that it's a different expectation around that these should be living documents, but even more important, I guess, is the idea that there's a reason why you're supposed to have policies and procedures, and it's not to check a box. It's that it's supposed to keep you compliant. So if you don't actually follow the policies and procedures, then it's totally pointless.
Absolutely, absolutely. It's not wise to go out and just purchase some policies and procedures and set them on a shelf and say you have them. They have to be something that's meaningful to your organization. They have to be something that is, again, the terminology of living document means something that you use and can easily be adjusted as things change in your environment. So it's very important to, again, that compliance officer to know what is in those policies and procedures.
Well, we've actually had a question along these lines already.
Okay.
And we've also had some questions from the audience asking about the slides and recorded versions of this. I just want to remind people that we will send that out after the event, but let's move on for now. So is HIPAA mandatory, and is this something we can blame on Obamacare?
Yes, HIPAA is absolutely mandatory. It doesn't matter if you have an electronic health record or electronic medical record, and it does not have to do with Obamacare, whether it is repealed or left in place. It doesn't have anything to do with the website for Obamacare working or not working. This is completely different from that, and becoming compliant, if you're not at this point, is definitely mandatory. I can't stress that enough. Don't wait until you're audited and then you're not only facing the fines, but then you have to be compliant anyway, and you'll also find yourself on the CMS wall of shame, announcing that you have failed an audit, and even worse, if if you're involved in a breach. So absolutely important to be compliant.
Yeah, so for people who may not be familiar with the Wall of Shame, for any breach of over 500 records, HHS actually publicizes the fact that this breach has happened, the organization responsible, to really publicly shame people for not doing what they're supposed to do. So that's another reputational risk that people may not be aware of.
Absolutely.
Well, there was a question, I just want to follow up on it now. To be perfectly clear here, they said, the question was, if you're not taking meaningful use incentive payments, can you stick with the old HIPAA and not have to worry about the HITECH Act and the Omnibus Final Rule? And you're saying that that's absolutely incorrect. You must comply with those regulations, even if you're not taking meaningful use money.
Yeah, absolutely. Meaningful use, you'll remember, is tied into the risk assessments based on Core Measure 15. That basically is a yes/no checkbox that says that you have completed a risk analysis. And for the people who do have EHRs and do want to take advantage of that meaningful use incentive dollars, whether Medicaid or Medicare, that is not the yes or no whether you need to comply with the omnibus update to the HIPAA rules. There is not 3 different checkboxes, so to speak. There isn't an organization that might need to follow the 96 HIPAA rules, an organization that might need to follow the HITECH Act of 2009, and other organizations that might fall in the omnibus rules and regulations. These all tie together, and they're all meant to protect patient health information. So it's very important to follow these rules and regulations.
So basically, in the Meaningful Use Program, they want to make sure that people are following HIPAA as part of their, the core measures for meaningful use. But that doesn't, if you're not doing it, that doesn't mean you don't have to worry about the new regulations. So it's
Correct.
It's not one or the
you do
other.
not have to worry. That's right. That's right. It is important to understand that even if you are not collecting meaningful use incentive money, you do still have to follow these rules.
So what are some safeguards that an organization could put in place right now?
So some safeguards that you could put in place right now is to certainly begin the process. That's very important. But on this slide, you'll also see that cyber liability insurance is becoming very inexpensive and very useful to have, because in the case of a breach or in the case of an audit, some of the fines, some of the legal fees can be very very costly. So immediately, it's an easy way to get some coverage for cyber liability insurance. I wouldn't wait. I would recommend all of your attendees, whether covered entities or business associates, to begin the process. Willful neglect will result in the highest penalties and fines. So if you show that you are beginning the process and that you're moving quite diligently and actively implementing your training and your assessments and all of the things we've been talking about, that will definitely put you in a better position than doing nothing.
So what are some tools and resources that people can use to help become HIPAA compliant?
Sure. So some of the old documents that you'll see in a lot of physicians' offices are the binders. You'll see their policies and procedures that were purchased as part of a bundle. Very important to understand that that is not what's considered a living document. Okay? Some of the solutions that are available, of course, live compliance, shameless plug there, but Live Compliance does help achieve this living document. It does allow you to implement everything that we've been talking about here, but likewise, the training aspect is quite important. Simply having a lunch in your organization and everyone signs a sheet saying that they've participated, that's really not going to cut it as we go forward into the future with protecting health information. It's very important that your workforce does really pay attention and really understand the rules, so much so that when you do take your training, it's mandatory to at least achieve an 80% within that exam. So I think the biggest point here, Brian, to stress is that this isn't something that office managers or business associates should take passively. They need to become engaged. They need to understand what the rules are and what steps to take sooner than later if they haven't done anything thus far.
Well, let's take a moment and talk a little bit about the portal and, as an example of the sort of thing that people may need. It's a great resource. And what it does in essence is it helps people manage their compliance so that they can keep track of all these things and be sure that everyone is meeting all the obligations that the regulations require. Is that correct?
Yeah, that's right. Its framework and its design is to help you stay compliant all the time. And what I mean by that is things such as deficiencies with your technical inventory, your device implementation or device deactivation, ensuring that you as the security officer are informed and notified of what needs to be done. If you have deficiencies with your workforce members as far as maybe their training has gone too long, they haven't been trained, or if they don't have confidentiality agreements on file, you're informed of all of this information so you can be compliant, keeping in mind that if you are audited, you have 3 days to respond. So all of this information needs to be readily accessible, able to be collected quickly, and provided in the case of an audit. And that's really the framework behind what Live Compliance provides.
Well, I'm glad you mentioned the audit, because I think for many organizations, frankly, if they got notice of an audit and had to start working through whether they've done, and maybe these are organizations that have made efforts to comply, but it's not the most organized effort, that I can just imagine the running around trying to track down everything, and inevitably they're going to find areas where they didn't actually do what they were supposed to do, whereas someone using the portal would be able to go in and say, yep, here's all the green lights showing that I've done everything I need to do. I can tell you where everything is. They'd be totally ready for an audit and wouldn't have to worry about anything because they know that they're compliant.
Yeah, absolutely. That's really the design behind it. Take into account a sanction policy. Yes, you have a sanction policy in place, but when you do need to leverage those sanction procedures against workforce members, the nice thing is, in the case of an audit, we have a one-click button that says, I'm being audited. It goes through the entire system, collects all of the information for you, and puts it in a format that is very easy to share with your legal counsel or share with the auditor.
So there's a lot more resources out there, I think, than people may realize to help them keep track of all these issues and to truly become compliant. We have plenty of time left for questions and answers. I want to thank you again, Jim. That was really informative, and we've already got a couple dozen questions, so we'll go through as many of them as we can.
Oh, great. Okay.
All right. Let's go ahead and begin here. So someone's asked, where can we find the document or the living document of what we need to know? I'm not completely sure what they may be asking, but I think maybe we've addressed it a little bit, is that when you're talking about a living document, you mean that these documents have to be dynamically updated and that they actually have to be implemented in the practice, not just something, you know, put away and then you're done.
Absolutely, that's correct. A living document, when that term is used, it means almost like a journal, so to speak. A journal would be a living document where you use it on a regular basis. You know where it is, you know what's in it, as opposed to that binder on the shelf. You know where it is, but if you were ever questioned on what's in it or what to do in the case of a breach or what to do in the case of terminating a workforce member, or what are the workforce clearance procedures for your organization, those are the things that they mean by a living document. You can't say, yes, we have policies and procedures, but not actually use them within your organization. The living document piece, or that living document terminology, means that it's something that's fluid, that's used on a regular basis, and the compliance officer leverages to ensure that that organization is compliant and remains compliant. Does that answer the question, Brian, or is there any feedback kind of further explaining what they meant by that?
Not yet. I think it was a good answer, but we'll certainly encourage them to ask further if that didn't address it. Here's a very interesting question from somebody about business associate agreements. So I'm just going to read it to you. I had a technology company initially ask us to sign a business associate agreement, which I didn't think was right. They're not a covered entity, and they don't store any PHI. The technology company works for us, and by us, we're a covered entity, and may see the PHI as, our PHI as part of their service and support. So they have to sign a BAA for us. Is that correct?
Yeah, so you as the covered entity would typically present that business associate with a business associate agreement that you have presented to them because you're using that IT company and they do have access to your protected health information. Now, keep in mind, if the IT company presented you with a business associate agreement, that could be good. Maybe they're very proactive. Maybe they are certainly, it sounds like they're very engaged with the rules and regulations. And keep in mind, a business associate agreement is a bi-directional contract. Now, the contract of a business associate agreement identifies each of the parties. So it identifies you as a covered entity, and it identifies your IT company as the business associate, right? So that's your instrument of identifying the different organizations. So by them presenting you a business associate agreement, that's okay, as long as you're okay with the language that's within it. Keep in mind, excuse me, the language that's in that business associate agreement does not supersede the Omnibus Rule. So any of the rules and regulations that are within the Omnibus Rule take precedence over whatever is in that business associate agreement. So the point I'd like you to take away from this is, if you feel comfortable signing that business associate agreement, that's fine. But you as the covered entity, you could ask them to sign your business associate agreement if you feel more comfortable with the language, or if your legal counsel, advised you to do so. I wouldn't just sign it because they presented it to you. Again, read and understand and engage in what you're signing, because times are definitely different than years ago, where just signing the business associate agreement was kind of the norm.
All right. Well, here we have a question about who is a business associate. And the question is, would the regulations also apply to a cleaning crew or a construction company?
That's a great question. So a cleaning company that comes into your practice or comes into your organization would not sign a business associate agreement, because you are not acknowledging, or you are not joining into a contract with them, allowing them or acknowledging with them that they have access to your protected health information. The cleaning company should not have access to that protected health information, and if in their job duties of cleaning the office, they take or view or do things with the protected health information, that then becomes a crime, and the Department of Justice handles that. But by entering into a business associate with that cleaning company, you're acknowledging that they do have access to protected health information, and that's not the case. So no, cleaning companies, construction companies, they would not have business associate agreements signed with your organization.
Right, so for them to have access to the PHI, either you've got unsecured computers or you've got unsecured paper records, because otherwise there should be no way for a cleaning crew to have access to that material.
That's right. That's absolutely right.
Okay, well, great question. We've got a lot of great questions here. So I'm going to move on to the next one. This is about disposal of hardware.
Mm-hmm.
How are healthcare providers supposed to dispose of old computers, copiers, fax machines, etc.? We know that these all house pieces of ePHI, but we can't figure out what to do with them when their useful life has come to an end.
Mm-hmm. Good question also. What you need to do, and again, this goes back to that living document, you need to be able to show, and you need to keep track of your technical inventory, so that when that computer or device comes to the end of its life with your organization, you can document what steps you have taken to deactivate it, or ensure that it has been properly cleaned of protected health information. Now, what you do to actually properly clean that device of protected health information is to follow the National Institute of Standards and Technology's guidelines for scrubbing a computer. It's very easy to do that. A lot of times computers, we'll pick on a workstation. A lot of times it's very easy to remove the hardware that contains that storage and properly crush or dispose of that hardware, much like you do with shredding companies, where there are certified companies that follow the National Institute of Standards and Technology guidelines and properly destroy that information. So I would refer you to that NIST guideline. It is the I believe the NIST 8000 guideline.
Well, that's great memory, and I think that's a good point to clarify, is that HIPAA is often very general and doesn't necessarily tell you exactly how to go about doing the things you're supposed to do, but NIST then provides that additional guidance so that you can actually get down into the details of how to get rid of hardware.
Absolutely. Mm-hmm.
Right, well, we have another question. If you're an independent contractor and you want to ensure that business associates and covered entities that you're working with that they want to retain your services, what are some good suggestions on providing validation or proof that you're actually compliant with the Omnibus Rule?
That's a great question also, Brian. Yes, so to provide, if you're a subcontractor or you're a business associate and you want to be able to provide your upstream client, maybe a covered entity or an organization, with some proof that you are compliant, the first thing that I would do is offer them your workforce certifications of training to show that you have trained your workforce on security and privacy. You can also give them the date of your last risk assessment and that you have mitigated what you feel is the the most risk and vulnerable areas within your organization. Now, I would also clarify that many of the legal teams that we work for also suggest that you as a covered entity who are inquiring to a business associate whether they're compliant or not, you don't have to read and understand and challenge an organization's policies and procedures. What you need to have is what is called satisfactory assurance that that organization is compliant. So I think by sharing your training, by sharing your risk assessment dates, by maybe showing the last revision of your policies and procedures would give that organization that satisfactory assurance that you have taken the necessary measures within your organization to be compliant.
Well, that's great advice for people. Here we have a brave soul with an unusual question. I don't know that anyone's ever asked this before, but I think it's probably an easy answer. The question, and the reason, you'll see why I call them a brave soul. Where can we get a copy of the 500-page regulation so we can read through it?
All right.
Leisure reading.
Someone's looking for something to do this weekend.
I guess so.
So the HIPAA privacy rule, the best place to go is hhs.gov.
I think they're asking about the Omnibus Rule is what it sounds like.
Yeah, so hhs.gov, you can actually download the PDF. You can get all of the proposed rules and the final rules, and you can read as much as you'd like about that. That's the best place to get it.
And they've come a long way, I have to say, at HHS on their HIPAA resources. It's still not always easy to find what you're looking for, but there's a new audit protocol tool that people can go to there that lists the regulation, and that sort of goes into our next question. And that question is, where can I find information about the requirement to comply? All I've seen is, penalties and that sort of thing. So I think the issue is, if you want to prove that someone has to actually do this, HHS would be a good place to go?
HHS is the place to go. Very simply go to, and maybe this is a follow-up, Brian, that we can send out to everybody, is a link to get that Omnibus 563-page document, as well as if you go to the hhs.gov website, right at the top there's that little search area. If you type in Omnibus, you're going to immediately get a lot of really good information. And yeah, that audit tool is just wonderful.
Yeah, it's really nifty.
A great resource. Great resource to find the different statutes and exactly what's required and what's addressable. So very, very good tool. We should send out that link as well. That'd be good. All right.
We'll be sure to send that out to people. Well, I don't know what this question means. Maybe you know. The question is, what is or was the effective date for self-pay restricted PHI compliance?
Oh, okay. Yeah, okay. So I think what they might mean by that is in the Omnibus Rule that went into effect on September 23rd, which is what we've been talking about, there is a self-pay or cash pay portion of this rule, and I'm quickly looking for the statute number. I'm going to have to follow up with exactly where this is for you as a follow-up. But in I think response to your question, if a patient comes into a doctor's office, for example, and they are a cash payer, now they have to be a cash payer for the entire treatment, not a portion of it. But if they're a cash payer, they have the right to not have their health plan notified of that treatment. Okay? Now, as a covered entity, this isn't something that you have to ask of a patient that comes in. It is up to the patient to say, I'm a cash payer, I know you have my insurance information on file, but for this treatment, I'm paying in full, and I do not want my health plan to be notified of whatever the diagnosis or procedure codes, etc., are. So yes, that if I am understanding your question, I think what you're asking is, does the Omnibus Rule allow for patients to pay out of pocket in full for treatment and thereby not have that treatment shared with their health plan? And yes, it does. And Brian, I'm looking on my screen right now, and I don't have that right in front of me, but I will follow up with you on the exact statute so they can reference that back here after the meeting.
Well, that's certainly very interesting. I've never heard that one before. I think we have time maybe for one quick question before we wrap up. The question is, how do we, hold on, we've got more questions flying in, and I want to stress to people, if we don't get to your question, Jim will follow up and address those questions after the session. Anyway, the question is, how do we instruct timeshare offices that our physicians go to? Do we have a responsibility for the offices?
A timeshare office, meaning if a covered entity is in an office for 1 or 2 days a week, and then another covered entity is within the office for a couple of days a week, how do you handle that environment?
That seems like a fair interpretation.
Yeah, so it's going to be up to let's just say if I'm a doctor in an office on Mondays and Thursdays, but not there the rest of the week, it's going to be up to me to properly secure any protected health information documents that I leave within that environment. So that would go towards your physical safeguards. So even though you're not there on Tuesdays and another doctor's office is there on Tuesday, it's very important to know you're still responsible to protect that health information. Just because there's another doctor in the office, that doctor, if they are not providing care to that patient, does not have access to your protected health information. So just because they're two doctors sharing an office, they still need to protect that information accordingly. And I think, if I'm understanding the question, that would probably fall under physical safeguards.
That makes sense. That makes sense to me. All right. Well, I'm afraid we have run out of time. Great questions from our audience today. So thank you, everyone, for submitting those questions. And as we said before, some of those, Jim will provide additional detail on the written responses to those. So keep your eyes peeled for that. Thank you, Jim, for joining us. Great session today.
Thank you very much. Absolutely.
Well, I'm glad we got to talk a little bit about live compliance, but I certainly would encourage people to go to www.livecompliance.com to learn more about the portal that Jim was talking about today. Again, I'd like to thank...
Thank you, Brian.
Yeah, thank you. And again, I'd like to thank all of our attendees. Remember that you're going to receive an email with links to both the slides and the recorded version of this session. Format Approved offers convenient, robust online education on HIPAA rules and regulations. So if you're looking for that training piece, we certainly have tools available for you. Visit formatapproved.com/education/courses_security.html to learn more about that training. We offer workforce training and also training for the compliance officer. If you need a risk analysis or HIPAA documentation, visit the second URL on your screen. That's formatapproved.com/education/HIPAA_secure for our services along those lines. Visit formatapproved.com to learn more about our upcoming Learning Lunches. The Learning Lunch button on the bottom of the screen will take you to our entire slate of upcoming webinars where you can learn more and register. Our next Learning Lunch will air on November 6th, that's tomorrow, and we'll cover the subject of PQRS for clinicians. Our own Joy Rios will be joining us for that session, always very popular. Keep an eye on your email box on our homepage for other upcoming topics, and thank you again for joining us today.